Good morning. Happy Tuesday. I read the Craig Hendry appellate opinion yesterday, so a little fuzzy in my head, and I don't really care about Craig Hendry, but I still get people commenting in my videos about Lane Myers, generally from Lane Myers supporters who think that somehow that I was dumb and wrong and that he should have fought it and that it was First Amendment protected activity and Lane Myers is a legal genius whose one big mistake was taking a plea. He should have fought it, they say, because he would have won. Well, I think Craig Hendry's appellate opinion is instructional on that. And the reason why I say it is because there are a lot of similarities between the two of them. Number one, they were both charged under a general harassment statute. Some distinctions is that Lane Myers was also charged under a specific version of the general harassment statute that made it a felony to commit harassment after there was a restraining order in place, but it's still just a general harassment statute. And Lane Myers was also charged misdemeanors for general harassment. Craig Hendry was charged with, I think, one felony, a low-level felony for general harassment, and like two other misdemeanor charges for, I think, general harassment. So very similar. They both were targeting people who are probably not public figures. Lane Myers was targeting the victim who was like, at one point in time, she was director for special programs or something like that. I mean, basically a glorified admin. Had no real contact with the public generally. Had no real power over Lane Myers or anybody else. Not a public figure that I can see. If I was placed in a position where I had to argue for the benefit of my client that she was a public figure, I would tell my client that it's probably going to lose. But, I mean, I'd make the argument, but, if I was a judge, I'd be like, it's probably not a public figure. Not that that really matters. And Craig Hendry was targeting his secretary. Again, low level, nobody basically. Why would you be upset about it? The secretary apparently had grandkids, so she's an elderly woman. Like, why are you picking on an old lady again? Tough guy. And both did general asshattery, a mixture of speech and actions. Both of them incited their followers to call by publishing phone numbers and stuff. Didn't expressly state it, but the implication was strong enough that people knew. The followers certainly knew in both instances to call and leave harassing voicemails. Apparently in Hendry's case, there was like, every time Hendry put out a video about this with the phone number, the gal would get like 500 extra calls. I mean, that's a lot. And a lot of harassing messages, a lot of death threats, things like that. So very similar cases. Both of them tried to argue Myers in pretrial briefs, motions, and Hendry at trial itself and in his appeal that a different criminal statute didn't apply. Well, he wasn't. Neither one of them were charged under the statutes that they were arguing. Like Hendry was arguing a telephone harassment statute. Well, he wasn't charged under that. He was charged under a general harassment statute. Why would you argue against a statute that you weren't charged with or convicted of? Like, why would you do that? Doesn't make any sense. But Lane Myers did the same thing. He was arguing all sorts of different statutes, like employment harassment statutes, and telephone harassment statutes, etc. He was arguing all sorts of statutes that he wasn't charged with. It didn't make sense to me at the time, and I pointed it out at the time. And then they both also argued First Amendment grounds. And First Amendment grounds, they're either as applied or on the face. So you could say either the statute is unconstitutional because on its face it restricts First Amendment activity, or as applied to my particular situation, it restricts First Amendment activity. But the issue with both of those is it has to be pretty explicit. So on its face, it has to catch, or the court has to figure out it's designed to primarily catch otherwise valid constitutional speech. And every every harassment statute that I've ever looked at has already gone through the on its face review. They've all been looked at for validity on their face. So the only argument you really have is as applied, but as applied really means that all you've done is protected speech. So we saw that in the Lane Myers case, where the gal was on her own property in her front yard, criticizing the police for their handling of a guy who's threatening to kill himself, right? And the police charged her with, I forget what they charged her with, but that was an example that I think we covered in Myers. That wasn't directly applicable to, if I remember correctly, the harassment statute, but where the otherwise valid law, as applied to her, because all she was doing was speech, wasn't. It was a violation of her First Amendment right. But again, the issue with both of these guys is that they did other things. They did other things besides just speech, and specifically besides just protected speech. First of all, they weren't targeting public officials. A police officer is a public official. I mean, he just is. I don't know of any state. I know the federal all consider police officers to be public officials, but I don't know of any state that doesn't consider police officers to be public officials. Secretaries at a town hall or city hall aren't public officials. They're public employees, but that's a different word. A public official is someone who, generally speaking, has the ability to make decisions, significant decisions, that affect the citizens. So police officers can arrest you. They're a public official. Secretaries answer phones, take notes, do filing, things like that. Not public officials. They're public employees. I would also argue that even though Lane Myers' victim was a director at a law school that was owned by the university system, I don't think professors are public officials, because again, they don't make decisions. Yeah, they grade their students' papers, sure, but they don't make decisions that affect citizens. And I certainly don't think that her role as like a director of special programs or something like that at the law school, she didn't do anything that would affect any citizens, really. I mean, she was really just trying to get people to donate to special projects. So not public officials. So they're not criticizing public officials. They're criticizing public employees who are private citizens. And the things that they were doing, inciting their members to call and harass, probably not protected speech. Probably not. So the First Amendment didn't apply, even though both of them thought they did, and both of their fan bases thought they did. But the interesting thing is, because these two cases are so similar, factually similar, and because we have Hendry, who went to trial, lost, and then appealed and lost, I think that should give Lane Myers supporters an indication of what would have happened if Lane Myers had gone to trial. He would have lost. I mean, 99% sure. No guarantees, sure. Maybe the jury just completely shits the bed, possible. Maybe the prosecution shits the bed, possible. But I have a sneaking suspicion that he would have lost. If I had to bet money on it, he would have lost. And if he appealed it, he would have lost. I'm even more sure because the Court of Appeals is much less likely to make an egregious mistake of the law than a jury would or a prosecutor would. They have all the time in the world to sit and think about the law. They have law clerks to do research, whereas a jury has maybe a misunderstanding of the evidence. They don't necessarily know the law. They're just instructed on the law by the judge. And the prosecutor, they're basically performing and you make mistakes. I make mistakes all the time. I mean, it just happens in everyday. Think about how many times in everyday life you forget to say something, or you say the wrong thing, or you know, you get flustered by an objection. I mean, as an attorney, you get flustered by an objection. You forget your train of thought. You forget your line of questioning. So, I mean, he definitely would have lost on appeal. Like there were just no grounds for appeal there. So I hope this puts the Lane Myers thing to bed. I know it won't. I don't really expect Lane Myers supporters to be smart enough to understand the vast similarities between the two cases and the way they were prosecuted and the way the law works in the situations. Everybody just seems to think, well, I could say whatever I want because of the First Amendment, and you can't. Like, you just can't. Believe it or not, your rights to free speech are somewhat limited. Anyway, that's all I got for you today. Best of luck to you, Mr. Hendry. I'm sorry for any incarceration time you may or may not experience as a result of losing this appeal. I don't wish that on anybody, even if you were an asshole to an old woman. Thanks for watching. Have a great day.